Now we are going to discuss the chapter under the Maharashtra Land Revenue Code. Up to now in the class we have discussed the definition part. Then we have covered section 3 and 4, that is the basic principle that so far as the division of the state is concerned. Then we have discussed the constitution of revenue areas, in which we have discussed the Maharashtra state, that since we are discussing the land laws in the Maharashtra, we are specifically talks about the Maharashtra state, and the Maharashtra state is divided into the subdivisions, that is called as the revenue divisions, and as per section 3 of the MLRC, that is Maharashtra Land Revenue Code. So whenever I use the word here after MLRC, that is Maharashtra Land Revenue Code 1966, there are 7 divisions, revenue divisions in the Maharashtra at present. Bombay, then we have the Konkan, Pune, which includes the most of the district from the western Maharashtra. Then the Nanded district we have, division we have. Then we have Amravati division. Then we have Nagpur, and lastly the Aurangabad division. That subdivision again divided into the districts, and you are aware that there are 36 districts in the Maharashtra at present, and the district again divided into the talukas, and we are aware that there are 399 talukas in the Maharashtra. Now, so far as the lower revenue administration is concerned, we are aware the lowest officer of the revenue is the Kotwal, and thereafter the Talati, then there is the Tahsildar, or we may call as the Naib Tahsildar also, then SDO, then Collector. So this is what the hierarchy we have discussed. And of course, there is the concept we call as the Sajja. It's a division of the village, or the small village we call as sometimes wadi also. All these definitions we have already discussed. Now, uh, section 4, 3 and 4, just now we discussed. The latter part of the chapters, that is chapter number 2 and 3, that 2 rather, deals with the officers of the that is revenue officers. There are two kinds of the officers. One is that is land revenue, that is in respect of the land revenue, and the survey officer. Uh, at the beginning itself, let me clear one thing. This particular aspect, so far as the officer, their power and duties, we will discuss this later on at the time of the procedure before the revenue officer, because there is a separate chapter, or rather sometimes the question examination, the power of the, that is the officers, revenue officer, their power, duties, and the procedure before the revenue officer. Chapter 20 deals with this aspect. That aspect we'll discuss later on. But uh, directly we are going to jump into chapter 3, that is the subject of the land, especially section 20 to section 63 of the Maharashtra Land Revenue Code deals with this aspect. Now, even the title is given to the chapter that is called as land. Again, this particular chapter, that is section 20 to section 63, is subdivided in different part. So in order to avoid the confusion, because most of the students, they are aware, they are under impression wrongly rather, that this is very technical subject, all this, but it's very easy subject to condition. If you understand the hierarchy, the purpose for which the officers are appointed, what is their basic object, then it's very easy. But because nothing to discuss, even though it is a code, it's not such a lengthy code as compared to civil procedure code or the criminal procedure code. So it's restricted only to the land and land revenue. So the scope of the act is very limited, and therefore the subject matter and the provisions are very short and very limited and very easy to understand rather. And therefore we have subdivided this, the topic called as the land. And the first chapter which we are going to discuss, that is from section 20 to section 28. Now, what is this concept so far as the land is concerned? The first and basic rule, that the title of the land is with the state government. This is the general rule. This is what the section 20 provides. Now, what is this title? Title that we have already discussed, that is the ownership that deals with the state government. The question is whether the all lands. The answer is no. See, in definition we have discussed that there are two kinds of land: occupied land and unoccupied land. What is occupied land? That is occupied land by the government. I'm sorry, the private person. Unoccupied lands means the land which is not occupied, not used by the private person. In that respect, we call as unoccupied land. So far as Section 20 is concerned, this is deals with the unoccupied land. So what it speaks about? So it generally speaks and it generally provides that all the public roads, that is the highways and all these things, public road, lanes, paths, river, the bridges, duct, or the bed of the river, the bed of the sea, the harbors, and especially the land which is attached to or to the sides of the river, which is not occupied, which is not owned by the person, by any person, then such land belonging to the state government. This is what the simple rule is. That this is what the simple rule comes under Section 22. So basically, all these lands belonging to state government, and therefore any person encroached upon that property, this will be the encroachment on the government property, and the provision for removal of encroachment, all these aspects that we'll discuss later on. So basically, Section 20 says the land which is not capable of holding of the property, rather the word is used. It is not the capable of holding of the property. Those properties belonging to state government. If someone is the owner of the property, Section 20 will not be came into picture. So what is the procedure and who has the power? The same section provides that it is the collector of the district, subject to the order from the commissioner. Now what is he has a right to dispose of the property. Now what is that? Now why these particular provisions are included under Section 20? One hand, Section 20 says the government is the owner. Now, why this provision say it's given the power to the collector that is subject to the divisional commissioner? That it says, suppose in a society we are aware there are several persons, they are not having the lands, they are not having the holdings of the lands, they are landless person, and therefore in order to provide the land to such person, the power is given to the collector. The collector may, by filing the new procedure established by the law that we will discuss in other law, how the land is allotted to the landless person, that we will discuss. Some of the part we will discuss under the tenancy law, some of the part we will discuss under the Mamlatdar Code Act. But here, if the person is landless and the person has made an application, of course, from the Mamlatdar to the collector, then collector, with the confirmation from the commissioner, can distribute this land, which land which is provided just now we are described, to the person, that is landless person. That may be by the lease, that may be for the perpetuity. That particular characteristics we will discuss. The transferring the land by the government in perpetuity or for the lease purpose. That will be discussed by a next part. So it's a power of the collector. Then, if suppose, say for instance, if the land is allotted by the collector with the consultation of the commissioner to the any person, and if any person, that is we call as aggrieved person, raise an objection to this, then there is a procedure provided. The procedure is provided. He must show that he must make an application to the collector or survey officer, as the case may be, stating what is his objection in writing, of course. That why he is taking objection. He may say that, sir, this is the property which is belonging to me. This is occupied land. This is legally capable holding of property of. I am the holding of the property since so many years, or since three generation, fourth generation we are discussing, and how you can distribute the property behind the back. So if this kind of application is read, then it has to be made to the collector. It has to be made to the survey officer. Then what is the process? Then the collector or the survey officer, after hearing the person, after taking the inquiry, of course he has to submit all the documents, the proof as per his contention. Then the collector may pass an order, or the survey officer shall pass an object. Please bear in mind this order, or the order passed either by the collector or by the survey officer. This should be the in accordance with the order passed under the in Maharashtra Land Revenue Code. And if any person is aggrieved by the order, which order? the order passed by the revenue officer, whatever it may be. If suppose X person raised an objection setting for the which is the land which is transferred by the government to someone, that is collected to some person, he raised an objection, and unfortunately his objection has been rejected by the collector or by the survey officer. Then what is the procedure? Generally, we saw that the procedure is to file an appeal. Procedure is to file an appeal or revision in there some case, or sometimes writ petition. Here, some interesting provisions is provided. Of course, the aggrieved person may file appeal or revision to the appellate authority. That is, if it is order of the collector, then to the survey officer, then I'm sorry, the commissioner, or if it is survey officer, then the deputy, the officer, settlement officer of the land revenue. That will discuss the hierarchy later on. However, in addition to this, there is extra power given to the person, that is aggrieved person, whose application has been rejected or no satisfactory order has been passed by the collector or survey officer. The remedy is that he may file a suit in the court, civil court, that too within the 1 year from the order. Now this is something interesting. Which one? This kind of suit is a suit for, one is injunction and declaration. What kind of declaration? To declare that I am the owner of the property, and the collector order transferring the property, his own property, to another person is totally illegal. So this is something very interesting, because generally in a revenue proceedings, civil court has no power. Civil court has no power to discuss. But to this rule, this particular aspect is an exception provided in Section 20 of the Maharashtra Land Revenue Code, wherein the civil court has a power to decide the validity of the order passed by the collector. Of course, in that case, the civil court will not be believe or rely upon the only the order passed by the collector. The civil court will be direct the person that time to prove his ownership, to prove how he is in possession, to prove how the collector is wrong, and how he is entitled. It's just a declaration and injunction suit filed by the person. With this, now after the filing of the suit, the this procedure, the order of the court is of course appealable as provided under the CPC, because since it is a civil suit, the state, if the order of the civil court is in favor of the plaintiff, then the state government will file the appeal. The same procedure will be followed as per the civil procedure code. Now, therefore, Section 20 says, as a general rule, the state has a title of all the lands. This is what the sometimes title of the question itself explain. In that case, Section 20 play very vital role. And therefore the public road, lanes, length, the paths, bridges, dams, fences, or the bed of the seas, the bed of the rivers, or the surrounding lines of the, or the canal, water sources, all this property which is not the property, which is not the property belonging to any person, that property goes to the state government. This is what the simple rule provided in Section 20. Now there are several judgments on this point. I have already discussed these there are several judgments under Section 20. But with this rule, now let us proceed with the next aspect. That is the second part. Now let me clear one thing again. While discussing the land laws, we are not going to discuss all the sections in chronological manner. That like after 20, we are not going to discuss 21. But I have intentionally subdivided the chapters in by giving different title. Like we have discussed the first one. The title of the land is belonging to the state government. Now let us come to the second one. The power of the state government to acquire the land for the special purposes. Now this is something different. Now see, we have already discussed Section 21, that is the ownership with land with the state government. However, power to acquire, the word itself shows what is this power. That means that land is already in possession, already acquired by the private person. Then also the state government has the power to acquire the land for the special purpose. So what are those special purposes? Since we are discussing the Maharashtra Land Revenue Code, please bear in mind it is only for the purpose of the villagers, land, subject of the land. See, we are not discussing the urban land selling acts. So it is everything we are discussing the rural purposes. Like say for instance, what are the requirement for the ruler, or the those person or agriculture is deciding the rural area. On basis of that, the land is acquired. Say for instance, we are staying in the city. Suppose tomorrow the corporation has been established, and in a corporation, what are the beneficial work has to be done by the corporation? See, we require the roads, we require the footpaths, we require the gardens, we require the transport facility, we require the parking spaces, we require the decomposed places. Okay, there are several things that is required, and therefore the municipal corporation has acquired the land for the different purposes for the during that within the within the periphery of the cities. Same is here. In case of the villages, in case of the rural area, the power is exactly with the state government. State government may acquire the land for the purpose. No, what is the purpose? Say for instance, they cannot acquire for the agriculture purpose, but they can acquire for the any other purpose. Like say for instance, say for the in a rural area, the agricultures they are having the cattle, ox, cows. So what required? They require grass, and therefore reserve forests are required to the grass for the these domestic animals, and therefore state government has a power to acquire the land for the purpose of this the forest, and therefore this power is provided, and we are going to discuss under this chapter the different powers of the state government of the acquiring the land for the specific purpose under the MLRC. Firstly, we are going to discuss section 22. It says it's a general by general order of the state government, the collector or the survey officer, that is they are the agent of the state government, who the collector and survey officer, what can they, that they can acquire that unoccupied land. Firstly, the land which is not belonging to any person, it is unoccupied land in the village or in the don't write the cities or the towns, because we are talking about the village, or in part of the village. For what purpose? For the purpose of the forest. Now it is one of the duty of the state government to conserve the forest, and therefore they can reserve the forest, or for the fuel reservation. Now we have gas, but we are talking about 1966. So fuel, like wood required for the fuel purpose in the rural area. Even today also some of the portion that is required, and therefore the fuel purposes they have reserved the forest. Ah, the free postulates for the village cattle, that we call as the gairans. Gairans means the reserve forest for the cattle purpose. They're there for the cattle's purpose, and also for the field reserve for the purpose of the cattle, and the grounds of the towns. What is this grounds? Sometimes, sometimes the state government has the power to reserve certain grounds for the doubting purpose. Like if they are having the temples, they can reserve certain property for the temple purpose. We call it as veranda in Marathi. So that power is absolutely with the state government. Apart from this, the unoccupied land, the state government can use for the road purpose, use for the lane purpose, drainage purpose, park purpose in the village, or those all the purpose in the public authority in the village. I'm talking about this is power with the state government under section 22. Apart from this, there is a new section inserted under the Maharashtra Land Revenue Code, that is section 21A. It says if the that this is the prohibitory sections, which prohibits that if the land is acquired or declared the Gairan land under section 22. Gairan. See, this is the Marathi word. Gai means the cow, Ran means the field. So whenever any reserve, the forest or any land is reserved for the forest, I'm sorry, for the cow and cattle purpose, then that is called as Gairans. That is the state government power under section 22. And section 22A provides that it's a restriction over the change of the use. It says the state government can restrict, prohibits the use of the Gairan for any other purpose. Once the state government declares that the Gairan is there, then it cannot be used for any other purpose except in some exceptional circumstances. In some exceptional circumstances, if the state government comes to the conclusion that now Gairan is not required for the particular village, and and for the public purpose, some project can be inserted on that project, that is central government project or the state government project. Of course, that is the project that is helpful to the agriculture. Then the state government may transfer this government land either to the state government that particular project, or to the central government. But the project should be for the for the agriculture, like say uh, milk storage plant. This for that purpose also government can allot the property, but it should be for the uh, agricultural purpose only and not for the other purpose. This is what the section 22 subclause A says. Similarly, section 23, so 22 were discussed, that is the power of the government to acquire. So 22A, that is the special protection to the garden land. And now 23, now it says if any land which is used for gathering or the pre-postulate of the land, that is for the cow and house purpose, ज्याला आपण जनावरे खाण्यासाठी म्हणतो, then it shall be extend only to the cattle of the villages. Now this is very interesting aspect. Say for instance, now the villages, they are divided the boundaries from one village to another village. That boundary we call as in Marathi number ban. Where the survey number start. That is called as number ban. That particular ban, that particular portion divided two villages. And if suppose the particular land is reserved for the forest or garden purpose by the state government under section 22, that is reserve forest, then under section 23 it says that forest can be used by the only the cattle from that particular village. No other person from the other village can use this. This is what the restrictions under section 23 which is provided there, uh, so far the powers of the state government is concerned. Now with this, now see 22, 22A and 23, this is with the power of the government. So let us go to the third aspect, that is with reference to the extinction of the rights of the public over the public roads. Now this is very interesting aspects. Since we are discussing the land, firstly we will discuss the ownership goes to land, then we will discuss the special power of the government to acquire the land. Now we are going to discuss the extinction of the rights of the public in or over the public roads. Now what is this? Under section 20 we had discussed, this is section 21 rather. 20 we had discussed, it's a government has a power to acquire the land for the public purposes, that is road, uh, tank, then the path, and etc. purposes. But section 22, 21 is exactly opposite to section 21. It says if under section 21 the government has acquired the land for the road purpose, and under section 21, if suppose if it is appeared to the collector after acquiring the land and after the road is in use, if it appears to the collector that the government road, I'm talking about the government road, not a private road. This is what section 21 says. It's very simple, that the government road is not required for the use of the public, because of the so many reasons, because of the availability of other roads or availability of the some substitute roads, or for some of the reason. I will give this small example, you can understand. Then he may publish. Now what is the procedure for extinguish of the road? Because that particular road is acquired by the collector. Now the public, they are using the road for their own purposes, but the now collector thinks that it is not used for the public purpose. Now what is to be done? Or for any other reason, collector may declare this. Now what is the procedure? Collector, before doing this extinguish the procedure, he has to publish the notice in official gazette, uh, that from this date, that mentioning the date from this date, now this particular government road which we are using since last so many days, now here no public person can be used for the particular purposes. The moment this notice is published in official gazette, then he has to call the objections. Now who may raise the objection? Of course the person who are using the roads. Then after taking the objection, he has to hear the objection. And it is very interesting that any member of the public or any affected member of the public, then he can raise an objection within the 19 days from the publication of that notification. And if within 90 days of publication, if the objection is not raised, then the collector may presume, or by presuming that there is no objection of public authority, he may discontinue the use of road by following the procedure of law. However, if the objection is raised within the 90 days of period, then he has to hear the objection in his capacity. he has to take the evidence, he has to take the all the aspects, claims, and come. And if suppose one of the objections of the person is, sir, because of you close the road, I am suffering this loss, whatever loss it may be, whatever loss it may be. I will give the simple example. Then there is a provision made under section 21 itself. It's a duty of the collector to compensate person because of this change of the use. This is what the extraordinary power given by the section 21 subclause 1. Now, if suppose after publication there is objection has been cured, then the the collector may compensate the person either by the as per the land acquisition act, that is the provision under section 9 to 10, 11, 12, 13. By following the procedure, he has to compensate the person so far the compensation damage is concerned. And similarly, the if suppose objection is raised and the order is passed by the collector, this order passed by the collector is only one appeal, that is subject to an appeal. That uh, appeal is made to the commissioner. This is what the procedure. And this is there is only one provision, that is the appeal. If the appeal the commissioner pass order, that particular order of the commissioner is final, whether it is against the government or against the person who raised the objections. So there is no procedure for further appeal. So from the claim of the collector, there is only one appeal provided. Sometimes it is criticized. That aspect we will discuss while discussing the revenue capital. But there is only one order, that is appeal provided under these sections. And one more thing. If suppose while passing the order, the collector directed to pay the compensation to the person, and if the compensation is not paid to the person, then the person, that is after, of course, if the compensation is not paid within the 6 months, then the person again in whose favor order is passed, he is entitled to take the compensation amount with 6% rate of per annum from the state government. This is another characteristics of uh, the section 21. Now what is this purpose? Now just we have to understand. Say for instance, suppose there is a road going, public road is passing through the attention to the village, and somehow the state government declared that there is need to construct new tank, I'm sorry, the dam in the village in order to fulfill the requirement of the water in the village. And of course, the survey officer carried the survey, the other government officer carried survey, and they fix one place. Now the problem of the state government is that the the place where they fix the place, in between this government road is passing. Now see, both are the beneficiaries function of the state government. Water is required, road also required. In such circumstances, by using the power under section 21, the collector may declare that this particular road is now affecting due to this dam. Now it is not useful because now it is going to in between the dam. If tomorrow due to the collection of the waters, we are unable to use this particular road, therefore he can close that road by using the power under section 21 of the Maharashtra Land Revenue Code. If suppose now why the compensation? Say for instance, attached to the road, as per the with the permission of the government, if any person has started the government or any plant, and if so, and the road is accessible, or it is useful because of the road, then if the tomorrow road is closed, the person is suffering, and therefore he may raise an objection in such case. Or sometimes land also came into picture. All this aspect can be challenged by the person under section 21 of the Maharashtra Land Revenue. So this is all about the part 3. That is the point number 3 of the this particular chapter. Now let us go to the 4th chapter, which I uh, made to so far as this chapter is concerned. That is with respect to the ownership of the state government and the power of the recover the amount. Now, what is this ownership? When we are discussing the land, And if you go to the section 2, especially section 2 subclause 16, it defines the land. And if you go through the definition of the land, it says land includes. Now it's an inclusive definition. It's not only soil and stone and all. It includes, now what are the things they have includes? Section 16, the benefit arising out of the land. It includes benefit means the mine minerals and all this. And and most importantly, like we are discussing movable and immovable property, the same word they are using, and that is the things attached permanently or fastened to the land. Now I am on this point. So far as the ownership of the state government is concerned. Now we have discussed the power of the state government for the reserve land. Land is going to the ownership land is with the state government. What about the trees? And therefore the fourth aspect, that is the last aspect, that is deal with the ownership of those things which is attached to the land, like trees, are the minerals, that is the benefit out of the land. And the fourth aspect deal with this aspect. Suppose the land is reserved as a government, that is the guarantee purpose under section 22. What about the ownership of the trees? What about the benefit arising out of the trees? Suppose there are 100 mango trees. Who will take the benefits? If there are other forest trees or medicine trees sometimes in reserve forest, who will take the benefit? Absolutely, ownership is with the state government, and this is what we are going to discuss. And therefore, section 26, the first aspect, it says all the trees in the jungle are in the reserve forest grown or by naturally grown or by the state government or in the reserve forest as provided in section 22. The ownership is with the state government. The ownership is with the state government. This is the simple provision provided under section 26. And to this rule, section 28 says, however, if in that forest some reserve trees are there, then the villagers in that particular village, they are allowed to take the trees, the branches of the trees, non-use of the tree, that is the trees which is not in use, that can be used by the villager for 2-3 purposes, like for the agriculture purposes, making the equipments for agriculture purposes, or sometimes for the fire, for the cooking the foods, like we have already discussed. In certain limit, that is what section 28 says. Up to certain distance, up to certain limits, the villagers are allowed, but they cannot destroy the trees. And therefore, if someone destroy the trees, then same section provided, then the fine is provided. The elements of fine is provided. However, if there is a dispute arising out of this land and the trees, then the matter will be decided by the collector of the district, and ultimately the power is with the state government to decide with how to resolve the disputes. And this is what section 28 says. Similarly, section 24 provides that if any person who is unauthorizedly cut these trees, this forest, then except for the special purpose, that is agriculture purpose, and for the domestic purpose, then such person, the government can award the fine to such person, and that fine is not exceeding 5 times of the value or areas of the lands. That depends upon the lands. This is what the provisions so far as the ownership of concern. Apart from this, there is another provision that is provided in section 27 of the Maharashtra Land Revenue Codes. It provides that if any person cut the trees, illegally cut the trees from the reserve forest or from the Gairan or some of the portion which is the reserve forest or to the roadsides, you can see some of the trees they are grown up in the roadside. If that is cut by any other person, section 27 made a provision. It says that particular person is liable for the criminal prosecution, and the state government can file a criminal complaint by using the power under section 27 of the Maharashtra Land Revenue Code. So it's not only the compensation, the criminal remedy is also uh, provided under section 27. Apart from this, section 25 deals with the very interesting aspect. It says it's a power of the state government to reserve certain forests, okay, wherein no person is allowed to enter in the forest. That is we call it the reserve forest. Sometimes you must have been heard the word sensitive eco zone. Nothing is allowed, neither the construction nor the cutting of the tree. This power is under section 2, and the government has a power to reserve these forests in order to. Now, what is the intention? Now, intention under section 25 is very interesting. Why they are preserving the forest? Why they are preserving uh, the trees? That is to preventing the erosion of the soil. What is erosion of the soil? Preventing erosion of soil. जर आपण जमिनीची धूप असेल, so sometimes by using the power under 25, the government can restrict to use the particular land, the particular trees in the particular area. So with this is all about the chapter we call as the lands. Next aspect, that is in respect of another part that we'll discuss in the second.